Now, this is not about whether Under Armour is a bully. It's not even about whether the marks are confusingly similar. What this is about is whether the small business owner could have prevented all of this. And if yes, how? My name is Andrei Mincov. I'm the founder of Trademark Factory. And in this video, I'm going to share my thoughts about yet another trademarking screw up. This time around, it's Under Armour going after a small business, small startup that Under Armour thinks is using a similar name. All right, I'm going to start by reading from the article, and you can always find the link in the description below. Under Armour trademark dispute puts startup plans on hold. Retail giant Under Armour has sued a family business in a trademark dispute over its name, Cascade Armory, officials said. Business owners Alex Short and his wife Diana received a cease and desist letter ahead of plans to open a retail front in Boise, Idaho, the Idaho Press Tribune reported Monday. Cascade Armory, official formed in 2017, selling flannel button-ups, hoodies, and beanies in Bend, Oregon, the Short said. The company found immediate success after years of advertising through MySpace and word of mouth in college a few years ago. Diana and the couple's two children live in Oregon, while Alex splits his time between Boise and Bend, the Short said. The Shorts filed to trademark the name Cascade Armory in 2018, according to the U.S. Patent and Trademarks Office website. The process is now on hold because of the legal debate. Under Armour cites trademark infringement, trademark dilution, and brand confusion over name similarities, officials said. Their whole basis is that people are only buying our clothes because they're confused and think that we're Under Armour. At this point, we hired lawyers, and even they said, well, this is ridiculous, Alex Short said. The Shorts and their lawyer originally were open to negotiate, officials said. I told them I'll rebrand, but you need to compensate me for what I've put into this, Alex Short said. Just for rebranding, it would have to have been about $200,000. They came back with a counteroffer of $200,000. Under Armour's patent lawyers told the Idaho Press to direct questions to the company's corporate communications team, but a spokesperson on the team said company policy does not allow them to speak on ongoing litigation. All right, so let's first look into what the small business has done, and then I'll provide the comments. So here's their trademark application, Cascade Armory. They filed it in January of 2018. They filed it for all sorts of apparel in class 25 with the basis 1A, claiming use from January 15th of 2018. All right. So all this story about them starting this in 2017, they may have, but they're not claiming it in their trademark application. And their trademark is currently published. It was published in July of 2018 after it went through the examination stage, and the examiners didn't see anything suspicious, anything confusingly similar. So if you look at the history, everything looks good, right? So the trademark examiner did their search, didn't see anything. They may have made a small amendment, and then they got the specimen, the application was published, and there we go. So, and after it was published, we got all of this as soon as it got published. So it got published, so it got published in July of Okay, hang on 1 second. All right, so July 10th is when it got published, and August 7th, they requested extension of time to oppose. Probably Under Armour wrote to them, and they couldn't agree. So in the end of the day, in January of 2019, Under Armour filed their opposition, and now they're going through all of that. And there was an answer in February so they're going through some procedural stuff. I'm not going to go through that in this video. But here's the interesting thing. As I always say, there is no reason in the world why anyone would want to run a business to build a brand they don't own, right? Because the more time, the more money, the more energy, the more love, the more passion you invest into building a brand that you don't own, the more it will hurt if you have to give up that brand. The more it will hurt if you realize that this brand is not really yours. The more it will hurt for you to realize that it's vulnerable to attacks like this. So what have they done right? They've come up with a brand. They have filed for the trademark, not immediately, but pretty close to the beginning. They filed for the trademark. The trademark went through the trademark's office system, so the trademark examiner didn't see anything suspicious about it. And now they're facing this opposition from a big company that claims that the marks are too close, that they are confusingly similar, and they're opposing based on that. And so the question is, could they have done something differently? Well, first thing is what I don't know if they did it, but what they could have known is when you do a trademark search, one thing you could get if you're using somebody who's helping you do the trademark search is if you see something similar or even somewhat similar, not necessarily identical, you also look at the opposition history of the owner of that trademark. So if you see that your trademark is kind of close, but not really, to a trademark that's owned by a company that's notorious for suing everyone, for opposing everything, you would know right away they're probably gonna oppose as well. Like, for example, a great example is Monster Energy, and they oppose everything. They sue everybody, right? Everything that moves, or Adidas, right? Everything that has stripes in it, that has something to do with shoes, you are kind of guaranteed that Adidas is going to sue you or oppose your mark. So if you see any similarity to that, you probably want to stay away from that brand. And Under Armour is known for going after people who use brands that have something to do with armor. So, and Cascade Armory, I don't think it's confusingly similar, but knowing what we know about the owner of Under Armour trademarks, it would be wise to come up with a different brand right away, as much as you love it. Maybe it's not necessarily trademark infringement, maybe it's not confusingly similar, but it doesn't matter. What matters is they've got infinitely more money, and as a startup, your obligation to your company is not to be right. Your obligation to your company is not to go out of business while you're trying to prove to the world that you're right. And that's a big difference, right? Because with law, you can be right all you want, but if you don't have the resources to prove it when somebody attacks you, you may just as well be wrong. It doesn't matter. So they got themselves in this situation. And also their claim that they want to be compensated, that was reasonable. The amount that they asked for was not reasonable, because it's not that you're going for the valuation of the brand. What you're going for is and also Under Armour's of course counteroffer is insulting, basically just the government fees for the trademark application. But what you're going for is your cost to rebrand rather than the potential value of the brand that's not really widely known. So maybe that would have helped the negotiation process. But either way, it's good for the small business right now that they're standing up for themselves and they're going through the motions, going through the opposition process, and hopefully they'll be able to prove that there is no likelihood of confusion, that the marks are different, and that when you evaluate confusing similarity, you look at first word in multi-words, right? So here, Cascade is the dominant part of the brand. That's probably going to be their strongest argument, that it's not about Armour, it's not about Under, it's Cascade, which is the first thing that people see, so nobody will get confused. But again, it will take some work. It will take some billable hours to pay, and it will get to the point when either they settle or it will be the opposition board that makes their final decision, and we'll see where this goes. But in terms of could they have prevented this from happening, could they have done something else? First thing they could have done is look at the opposition history of everyone who's got something to do with Armour and maybe Cascade, right? Just to do a proper trademark search beyond just making sure that nobody owns a trademark for Cascade Armory. And the second thing they could have done is they could have waited until the trademarking process was through before they started putting in big dollars into promoting that brand. And it's a tough one, because when you file your trademark, you already feel kind of protected because that's the first and most important step. But there is no absolute certainty until you get that trademark registration certificate, which is why you want to do it as early as possible. If they file their trademark in 2017 when they were just starting out, maybe even as a intent to use trademark, before they opened their store, before they started selling their stuff, that would have given them the time enough to hear back from Under Armour, and if Under Armour was just as unhappy with their brand, 6 months before, 8 months before, they could have walked away from their brand a lot easier, with a lot less regrets, with a lot less invested in it, and would have been so much easier for them to switch to something else. That is probably the biggest lesson here, and that's probably the way I would treat this, unless they have such deep pockets that they can just spend on lawyers to fight this all the way. And if that's the case, good for them. It means they have built something that generates enough business. But again, maybe all this money that they're spending on lawyers right now would have been better spent on promoting their brand, or promoting the brand they would own outright, and they could build up into something that's going to be as recognizable as Under Armour is today. We'll see where this ends, and if there's an update, we'll keep you posted. Now, if you've got a brand that you want to protect, if you want to make sure that before you file your trademark, a comprehensive search is being done, and you know exactly what's out there, and you know your chances of it going through before anything gets filed, with the comprehensive trademark search being included in all of our packages. Go to trademarkfactory.com and book your free call with our strategy advisor. With us, you get a comprehensive trademark search, you get one flat fee that covers everything from start to finish, and you get a 100% money back guarantee if your trademark doesn't go through. So if that's something that appeals to you, if you are running a business that you want to protect a brand for, go to trademarkfactory.com and book that call with our strategy advisors. If you found this video useful, if you learned something you didn't know, if you want to hear more stories about brands, about trademarks, about growing a business, subscribe and get notified whenever the next video goes live. And if you like this video, like it, comment, and I'll see you in the next video.